It was devastating. It was worse than a nightmare. I mean,
This grandmother spent nearly 2 years in prison, based only on the testimony of a documented liar. In our full disclosure investigation, we exposed how this Phoenix officer's history of lies was hidden from her attorneys and the jury. Tonight, ABC 15 investigator Dave Biskobing is going to show you the inside emails and documents that reveal how prosecutors sat on the evidence instead of fixing the injustice done to someone sitting in prison.
It's the end of the trial, August 2016, and this is Maricopa County Prosecutor Elizabeth Lake's closing argument.
Look at who has a reason to lie. Look at who might have lied before.
It's the word of Frances Salazar versus the word of the officer, Phoenix officer Anthony Armour, who with no other evidence, no body camera, no fingerprints, no drug tests, nothing, arrested Frances for drug possession after a traffic stop. Armour testified she admitted owning a pipe found buried between the seats in a car that wasn't hers, that she wasn't driving, something she denies.
This case is about responsibilities. This case is about who's responsible for the drugs and the drug paraphernalia that were found in the car.
Again, focus on the word, responsibility.
This case is about responsibilities.
The 1963 Supreme Court case, Brady v. Maryland, requires police and prosecutors to turn over exculpatory evidence, including evidence of past lies by officers. It's a responsibility almost 60 years old. Yet we obtained inside emails between Prosecutor Lake and her supervisor. Just a few weeks after Frances is sentenced to prison, Lake learns Armour is on the Brady list. He's a documented liar. And here's the first question she asks. Do I need to disclose a copy of the Brady packet? Frances's attorneys say the fact she even asked the question raises serious concerns.
Exculpatory information. This is something that gets Frances out of prison. You do everything in your power in that moment to make sure it gets to the right people.
It just shows a systemic failing in terms of policies and procedures.
Officer Armour is a police officer. He wouldn't have a reason to build a case against her for defense.
A year before Frances's trial, in another case, Officer Anthony Armour unlawfully entered an apartment, falsely arrested a woman who lived there, lied to his supervisor regarding the circumstances, lied in his incident report, and after a sergeant told him to release the woman from custody, he had her sent to jail anyway. The incident happened November 2015, 10 months before Frances's trial. Then Phoenix police completed their internal investigation April 2016, 5 months before the trial. But the defense and the jury would never know it, as Armour raised his hand and took the stand.
The defendant wants you to believe that she's the subject of some conspiracy to convict her. That's just not the case.
Frances sentenced December 2016. Armour isn't put on the Brady list until January 2017, when Prosecutor Lake writes the email. She also asks her supervisor, if I were to disclose the Brady packet, where would I file a motion for a protective order to prevent dissemination of the material for non-legal use? And how can we ensure that this material is not copied for the defendant or disseminated to other attorneys? Records show Lake waits to have a protective order drafted, files it in court 3 weeks later, but never sends the Brady material to Frances's trial attorney.
So they stuck information about his untruthfulness, his dishonesty, his lying, in a now dead old case file after the trial is over without telling anybody?
Yeah, and not even that. They didn't even put his conduct or his untruthful acts in the court file. It was just a notice of disclosure.
Even during an appeal, MCAO would stay silent for almost another year. It wasn't until December 2017 when Frances's attorneys discovered it, buried in the old docket.
You have a number of witnesses, all of whom have a reason to lie. You have an officer who got on the stand and told you, I went, I confronted her, and she said, I'll take responsibility for it. That's it. End of inquiry.
The final question in the email, is there something I could have done to prevent this? The answer, not if he wasn't on the Brady list until after trial. We expect you to be good, but not clairvoyant. Clairvoyant, claiming to have powers to see the future. Now, Armour lied almost a year before testifying. Neither Phoenix PD, MCAO, made sure those lies were disclosed. They either didn't check or didn't care. That's not a lack of clairvoyance. It's a failure, an unconstitutional failure. After the Brady file was finally discovered by Frances's attorneys, a judge ordered her release, granted a new trial.
Oh, I love you guys. Come here.
Lake then wrote this, quote, high-profile memo. MCAO conducted a new evaluation of the case and determined that given the officer's credibility problems, the state no longer had a reasonable likelihood of conviction. Meaning the first trial Likely never should have happened at all.
What they did to me is wrong, period, all the way around.
Is it justice?
No, it's not justice. There's no justice there at all.
I'm Investigator Dave Biskobing, ABC 15, Arizona.
We reached out to Maricopa County Attorney Alistair Adele and Prosecutor Lake. A spokesperson says they can't comment because Frances Salazar has filed a lawsuit. Since this case, the county attorney's office says they have changed their policy and no longer seek protective orders for Brady material.